Greetings and welcome to NIFA USDA's Civil Rights webinar on reasonable accommodations and accessibility for individuals with disabilities. My name is Jessica Creighton. I am the Senior EO Specialist, Equal Opportunity Specialist here with NIFA. And the objective of today's presentation is to provide NIFA grantees with an understanding of their civil rights obligations related to providing equal access and opportunity to individuals with disabilities within their programs and activities. NIFA civil rights staff does hope and expect that NIFA grantees are considering all aspects of civil rights issues and equal opportunity as a whole throughout planning and implementation of their programs and activities, and not just in preparation for a civil rights compliance review or not just in response to a civil rights compliance review that has findings. However, for your reference, the topic and the items that we will be discussing today is covered in Review Area 8 of our Civil Rights Compliance Reviews. This presentation is divided up into two sections. First, we're going to talk about applicable civil rights law that applies to the issues of equal opportunity and non-discrimination for individuals with disability and the requirements that are in those laws. And then secondly, we will talk about best practices for your programs and activities in terms of putting those requirements of those laws into context about what you should be doing when you are planning and implementing your programs and activities that are federally funded. So the first major civil rights law related to individuals with disabilities and equal opportunity for those individuals is the Rehabilitation Act of 1973. And the part of this law that applies to your programs and activities that receive federal funding is Section 504, which I've bolded. But I've put it into context with the other sections of this law to give you an idea of what the Rehabilitation Act is all about. And the Rehab Act really focuses on the federal government. So Section 501, for example, has requirements for employing individuals with disabilities within the federal government at federal agencies. Section 508 has requirements for federal agencies' web pages and websites. And so most of it just applies within the federal government, but Section 504 does apply to any program or activity that receives federal financial assistance, for example, through receiving a grant from the federal government, like many of your institutions do from NIFA. So Section 504 of the Rehabilitation Act is the first main law that's applicable. And you'll see here this quote, the Rehab Act, as I mentioned, was written in 1973, or the 1970s. And so you'll see the word handicapped and handicap used throughout implementing regulations for the Rehab Act and in the legislative language. And that's just because at that time that was acceptable language to use for individuals with disabilities. It no longer is, but when we do direct quotes, we do see some of that language. But as you'll see from the quote here, Section 504 states that no otherwise qualified handicapped individuals shall solely by reason of his or her handicap be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. The other major law that deals with non-discrimination and equal opportunity for individuals with disabilities is the Americans with Disabilities Act, or the ADA. And I've put, again, the title that applies to many of your institutions, those of you who are watching this presentation, in bold here, Title II, and then put it into context of some of the other titles, because you may have encountered ADA requirements in other contexts. And I've put in parentheses who those titles apply to. Title II does apply to state and government services and instrumentalities, and state public universities are considered an instrumentality under that title. But you'll see that the Americans with Disabilities Act applies much more broadly than Section 504. Title I applies to all employers. Title III applies to restaurants, hotels, grocery stores, retail stores. But just to give you some idea of what the ADA covers in general, but Title II is what will apply to, for example, land-grant universities. And as I said, Title II of the ADA requires that state and local governments and their instrumentalities give people with disabilities an equal opportunity to benefit from all of their programs, services, and activities, and it does apply to public universities. The reason I'm talking about who these laws apply to and focusing on that is because Title II requirements are based on Section 504. So in terms of the requirements and what these laws actually contain in terms of what they require and what you need to do, they're very similar. They're the same. The difference is that the Title II, the ADA as a whole, and Title II specifically to your situation extends those same requirements beyond just the federal government or beyond just those entities that receive federal financial assistance. So that's the major difference. But as we go into talking about who they cover and what they require here, we're going to be talking about these two laws together. Under the ADA and the Rehab Act, qualified individuals with disabilities are protected. And an individual with a disability is defined as a person who has a physical or mental impairment that substantially limits one or more major life activities, someone who has a record of such an impairment, or someone who is regarded as having such an impairment. These laws also prohibit certain kinds of discrimination against individuals due to their association with an individual with a disability. The first major requirement or concept in these laws is very similar to what we see in other civil rights laws. Just as a government office cannot refuse to provide benefits or services to an individual on the basis of his or her race, it also cannot refuse to provide benefits or services solely because an individual has a disability. So it prohibits the denial of services or benefits on discriminatory grounds, which is this case. In this case, we're talking about on the grounds of an individual having a disability. These laws also introduce this concept that individuals with disabilities must be provided with an equally effective opportunity to participate in or benefit from a public entity's aids, benefits, and services. So in these laws of equal opportunity for individuals with disabilities, we have this concept of providing an equally effective opportunity. So it's not always providing the exact same thing that you provide to an individual without a disability. And this concept is best explained, I believe, through examples. So I have 3 examples here that are very simplified and straightforward to give you an idea of what we're talking about when we talk about equally effective opportunity. For example, a deaf individual would not receive an equal opportunity to benefit from attending a research talk if he or she does not have access to what is said. So if a sign language interpreter is not provided, that deaf individual does not receive an equal opportunity simply by attending a research talk. An individual who uses a wheelchair would not have an equal opportunity to participate in an extension program if applications for that program needed to be filed in a second floor office of a building without an elevator because he or she would not be able to reach that office. Use of printed information alone also would not be equally effective for individuals with vision impairments who cannot read the written material. So a very, very important concept when we're talking about equal opportunity for individuals with disabilities. Another concept has to do with integrated setting and separate activities. And the idea is that services and benefits should be provided in the most integrated setting possible. And when alternative methods of providing program access to individuals with disabilities are made, that efforts are made to ensure that those alternative methods don't result in unnecessary segregation of individuals with disabilities. And this requirement stems from a long history of segregating individuals with disabilities and institutionalizing even individuals with disabilities from the mainstream of society. So it's an important concept to keep in mind when you are providing alternative methods of program access to individuals with disabilities. It is permissible to develop and implement separate or special programs for individuals with disabilities when you're doing so because you're specifically designing those programs to meet the disability related needs of those individuals. However, even when you do offer those separate or those special programs, individuals with disabilities still need to be allowed to choose which program they want to participate in. So you can't force an individual with a disability to accept those special services or to participate in those separate activities if they wish to participate in the regular program or activity. Reasonable accommodations and modifications. I did put both words accommodation and modification here. They have different meanings within different contexts and within different civil rights laws. For example, in fair housing, there's a distinction between what a reasonable accommodation is and a modification is. In many implementing regulations for federally funded programs, civil rights regulations for federally funded and federally assisted programs, the phrase reasonable modification is used to refer to a change in a policy or a procedure or a program. And many of you work for universities where the phrase reasonable accommodation is used in the educational context to refer to accommodations made for students. I don't really care about the semantics of this, what you call your policy or your procedure, as long as you are implementing it in such a way that you're providing equal opportunity and access by having a system in place to provide accommodations or modifications. So when we talk about reasonable accommodations or modifications, we are talking about a change or a modification that affords a qualified individual with a disability full enjoyment of an entity's programs or activities. Accommodations do not need to be granted if such modifications of policies, practices, and procedures would fundamentally alter the nature of the program, service, or activity, or result in undue financial and administrative burdens to the entity. Finally, these laws have requirements for effective communications, and that is that auxiliary aids must be provided at no additional cost to individuals with disabilities where it's necessary to ensure effective communication with individuals who may have hearing, vision, or speech impairments. And I have some examples here in parentheses of what type of aids those might be, what video text displays, braille materials, large print materials, interpreters, just some things that ensure that you're effectively communicating with individuals with those impairments. So moving on to best practices, putting this in context a little bit for, what do you want to do with your agency, with your university, with your extension or research programs, or other programs that you're operating with NIFA grants and fundings. What do these requirements look like in practice? And a lot of these best practices refer to each other, so I may mention something and explain it in more detail later on another slide, because they're all overlapping when we talk about some of these best practices. A major best practice is to have a reasonable accommodation policy and procedure. And some things that a reasonable accommodation policy should include, you might have, additional things that you want to put in your reasonable accommodation policy, but just some idea of some things that can go into a reasonable accommodation policy or procedure, and an institution's commitment to providing equal opportunity for individuals with disabilities, a statement about that, legal requirements and relevant definitions, directions for staff on how to recognize and respond to a reasonable accommodation request, including the interactive process. Examples of reasonable accommodations can be helpful, requiring the reasonable accommodation statement, so information about how that needs to be used. Requirements for denials of reasonable accommodations and alternative accommodations. The complaint processes that are available to requesters of reasonable accommodations, so that would be your normal Title VI, Title IX, complaint process that could also be used for someone to file a program's complaint, and consequences for violating the reasonable accommodation policy and procedure. Another best practice is to look for a reasonable accommodation statement. This is a statement that should be on event or activity announcements that are public facing. It should contain the name, title, and contact information for requesting a reasonable accommodation. It's a good idea to periodically spot check materials to ensure that the statement is being used. Have someone in charge of reviewing and checking and making sure at random that event announcements and public facing documents have that reasonable accommodation statement on it. And just a note that there is a general reasonable accommodation statement in USDA's non-discrimination statement for assisted programs, which is also on the And Justice for All posters. Another, best practice is to make sure you are training your faculty and your staff on reasonable accommodations and accessibility for individuals with disabilities. And this training should include obligations and requirements of applicable federal law. It could include disability etiquette. It could include or should include physical accessibility considerations, reasonable accommodation policy and procedure, the use of the reasonable accommodation statement, considerations about integrated setting, and inclusivity considerations. Another best practice is to handle reasonable accommodation requests appropriately. So some do's and some don'ts here about handling reasonable accommodation requests. You do want to make sure that you're engaging in an interactive process and that you're not dictating to an individual with a disability what type of accommodation will meet their needs. You can make suggestions of alternative accommodations or ask for clarification on what the individual's needs, disability-related needs are. And that's a part of that interactive process, is having that dialogue, that back and forth where you're not saying this is what we'll give you, this is what will work for you, but you're having that dialogue about, where you offer suggestions or ask for clarification on what an individual's disability-related needs are. And, that's asking about the disability-related needs and asking for clarification about that as a part of the interactive process is distinct from asking invasive questions about an individual's disability or for private medical information or records. You want the focus to be on how you can meet the individual's needs and have them explain that to you, not on the individual's disability and asking for information that you don't need to know in order to provide the accommodation. Of course, it's important to respond to reasonable accommodation requests in a timely fashion. And don't deny a reasonable accommodation request until you have engaged in that interactive process, until you have explored those possible alternatives and tried to work with the individual. And an individual with a disability does not need to, say this is a reasonable accommodation request in order for you to treat it like a reasonable accommodation request. If an individual with a disability contacts you and notifies you that they have a disability-related need in order to participate in one of your programs or activities, that should be treated as a reasonable accommodation request, regardless of whether they actually use the technical language or not. Another best practice is just to take accessibility for individuals with disabilities into account throughout your process when you're planning and implementing your programs and activities. You can collaborate with local disability rights groups. You can consider your local populations and your local needs. The area that I grew up in, Frederick County, Maryland, had one of the largest deaf communities in the country. So if I were, in an extension office in that county or in that area or in that state, that's something that I would be aware of, want to be aware of, that there's this population here that has needs, because of the Maryland School for the Deaf being there and Gallaudet University. So be aware of your local situation. And if it's appropriate, you can, as I mentioned earlier, develop programming to meet specific needs of individuals with disabilities, as long as, they're still able to participate in regular programming. When you are choosing physical meeting spaces, keep the physical accessibility of those meeting spaces in mind. Make that a part of your consideration. When you're educating, recognize and plan for the fact that there are different ways to learn. And when you're communicating, issuing marketing communications or any type of communications, recognize that there are different ways to communicate and try to utilize different methods to communicate to reach a broader audience. And, periodically evaluate the accessibility of the technology and the websites you use and look for ways to improve them. Lastly, utilize and promote disability etiquette. This includes using what's called people first language, which recognizes that individuals are more than their disabilities. So saying an individual with disabilities or an individual with a visual impairment or an individual with a learning disability, as opposed to saying, the disabled as a noun, or saying a disabled woman. Using that people first language is preferred. Don't ask questions about a person's disability unless it's brought up by the individual. If you offer assistance, wait until the offer is accepted and then listen to or ask for instructions. So again, This next item, don't be afraid to ask questions when you are unsure of what to do. As you know, asking questions about what to do or how to assist, or what the disability related need is, as opposed to asking questions about a person's disability itself, particularly when it hasn't been brought up by the individual. Speak directly to the person and treat adults as adults. Address people who have disabilities by their first names only when extending the same familiarity to all others. So treat individuals with disabilities with the same formality that you're treating everyone else. My contact information, please feel free to reach out to me via email or phone if you have any questions or concerns about the content of this presentation or any other technical assistance matters related to civil rights and equal opportunity within NIFA funded programs and activities. I am happy to answer any of those questions. We do have a civil rights listserv where we distribute information about equal opportunity and civil rights matters, policy changes, directions, written guidance, and we also issue information about our upcoming webinars when they are live, and any additional resources or activities or trainings that we are planning to that listserv. If you are not on that listserv and you would like to be, please reach out to my colleague Lydia at this email address. And just as a note, all of our training videos can be accessed on our website. They are available in PDF format of the PowerPoint slides, and on the last slide of each PDF PowerPoint is a link to a video that you can view, actually a recording of the entire training if you prefer to review a video of the training as opposed to the slides themselves. And to open those PDFs that are available on that website, the password is equal opportunity, capital E, capital O, one word altogether. Thank you very much for joining me for this presentation and viewing this presentation. I hope you enjoyed it, and I look forward to seeing you in future webinars. Have a great day.